North Carolina's dietetic statute is actually somewhat in line with the rest of the nation's in terms of their licensure, and I think that's a good thing. So now that we've covered Guideline A, what actually happened in the Cooksey lawsuit? How did we fare on these three things that Cooksey did that the North Carolina Board of Dietetics objected to? Well, the life coaching service, Steve Cooksey basically stopped providing that by the time that the lawsuit rolled around. Candidly, it's a pretty clear violation of the dietetic statute, right? He charged money, he did one-on-one consulting, he was treating a medical condition of diabetes. It looks and smells like a client or a professional client relationship. And he's treating a medical disease, which is really the purpose of a dietitian. So if he had gone forward with this challenge, I am pretty sure he would have lost it. But the other two are okay. Because think about it. Dear Abby advice column, it's on a public forum, he's giving information for free, and so, and it doesn't really resemble a professional client relationship. And then creating a forum for others to pose questions that he periodically participates in, it's basically sharing his own experience, maybe commenting a little bit and having a discussion. Again, it doesn't look like a professional client relationship. So what are the takeaways we have here? Well, number one, and my favorite takeaway, Jordan's Nutrition Forum appears to be okay, right? Because that's kind of what Jordan does. These number one and number two are basically the nutrition forum for our group. I think this indicates that those are okay. I know we've had some questions before about, well, is this potentially an issue if it were in a Category 3 state? I don't think it would be. But a couple other takeaways. In other words, how do you protect yourselves from inadvertently becoming liable under dietetics law for what's called the unauthorized practice of dietetics? Well, number one, don't charge for dietary advice unless it's a really important part of your business. If you charge, it looks like a professional client relationship. Include disclaimers in coaching contracts that you are not a licensed nutritionist or dietitian and you're not offering dietetics advice. Why? Because then you're disclaiming it. That's one of the factors that North Carolina's Guideline A considers. Give general advice when possible, rather than giving specific advice tailored to the individual. It is much better to say, in general, if you don't have a certain amount of protein, you're not going to recover, rather than saying, you specifically need to have this many grams of protein. If you do give specific advice to clients, which I understand you may want to do in certain circumstances, don't phrase it in terms of health or treating a disease. Definitely don't phrase it in terms of a disease. Phrase it in terms of performance. Right? If you want to perform better, if you want to hit this next work set, if you want to not be as sluggish, this is what you should be doing. Relying primarily on personal experience and anecdotes as opposed to trying to tailor your specific message to them, right? If you share your own experiences, that's explicitly carved out under the dietetics. And then, to the extent you can, provide advice on public forums, something where everybody can read it, because then it doesn't look like a client relationship. If it's one-on-one, it looks a lot more like a client relationship than if you're just speaking to a crowd. And also, if you are going to say something that might be objectionable, which of course you would not do, but if you have a question about it, don't put it in writing. Right? If it's not in writing, they can't prove you said it. And the question for those watching later on is, if you tell a client, here's what you need to do to lose weight, is that considered performance, or could you potentially be liable under the statute? I think this would fall under what's known as medically unsupervised weight loss. And I think that you can say this, I think you can give general information about what you need. I mean, calories in, calories out, don't have a whole bunch of sugars. This is all pretty well-known dietary information, and it's not something I think you need a nutritionist to do. So I think you're going to be fine there. I think where the problem comes in is, for example, if you start creating meal plans for them, like specific meal plans that they need to follow, that's where you might potentially run into problems. But as long as you don't, as long as you keep it out of that realm of specificity and keep it more to, you know, try to lower your calorie count, I mean, stuff that we intuitively know, I think you're okay.
Maybe again, don't write it down.
I'm sorry?
Maybe again, don't write it down.
Yeah, maybe again, don't write it down.
All of this
Yeah.
applies in this category 3 states, right? I mean, category 2, none of this would really.
Yeah, and the question here is, this only applies in category 3 states. Yes, but I'm going to qualify that. If you are physically in a category 3 state and you give advice to somebody in a category 3 state, it's pretty obvious that that particular state's law applies. Here's the interesting question. What if I live in a category 2 state or a category 1 and the person I'm giving advice to is in a category 3? Whose law applies? And this is something I talked about in the article last year that I wrote on this. I think the answer is both laws. I think that you would be liable under that other state's law because you are directing a communication to somebody in a category 3 state. I think, you know, and I'm sure Dr. Sullivan could talk about it. This is the problem that a lot of doctors had with telemedicine back when it first came out, that you had issues with, you know, if I have a doctor in one state and a patient in another, do I have to be licensed in both states?
You mean on some sort of electronic platform or through media? I mean, if you have a
Yes.
person who's come from another state that you're consulting with, the laws of the state that you're in apply. If you're like communicating with somebody in another state.
Yeah, important clarification. Yeah, if they come to visit you, that's one thing. I'm talking about a situation where they are physically present in their state, you are physically present in yours, and you're doing electronic communications back and forth. So the question is, if you become a registered dietitian and you start giving advice that is contrary to what you learned, what happens? And I think that is an issue that ultimately, it comes down to what the particular dietetics board says will happen. So a lot of the boards of dietetics will create standards of practice. And if you fall outside of those standards of practice, you're subject to professional discipline. So now, exactly how far you have, you know, what the standards of practice are, whether what you do falls outside of them, it's, you know, it's a little bit beyond the scope of what I can do because frankly I haven't looked at them that specifically, but it's just like any other profession, whether it be law, medicine, physical therapy. If you breach the standards of conduct, you could be subject to discipline. So let's go to the third topic. Unfair competition and deceptive advertising. Why am I talking about this? It sounds really scary. I'm talking about this for two reasons. Number one, the Federal Trade Commission, the FTC, and its state law counterparts actually have laws that say what you can and can't say in advertising materials. Well, if that's the case, we should probably know what those laws say, because it governs how we're able to advertise our services. But there's another reason why I think it's really important. Over the last 20 years, the FTC and its state law counterparts have paid an especial attention to the fitness industry. And in fact, there was something that the FTC did in the late 1990s called Project Waistline. It was actually a formal program they did where they went after certain supplement companies and certain exercise equipment. And every year, if you go to the FTC's website, more or less every year, someone, whether a supplement company or somebody who creates a piece of exercise equipment, is liable and they get a big fine. I'm sure all of you remember those stupid shoes with the round bottoms. That was, yeah, I forget what they were called. What? Shape-ups. Yeah, so shape-ups, I'm sure you all remember they got a massive fine for that. You might remember the ab rocker, or not the ab rocker, the ab wheel, the one where you hold the thing and move around, and like if you did it for only 3 minutes a day, you would shed pounds. Yeah, I think they got a $67 million fine. So the point is, This is something that the FTC and its state law counterparts are really starting to pay attention to. And given that our organization is starting to grow, and given that we're starting to have a really big impact on the industry, the bigger you are, the bigger the target is on your back. And so I want to try to help everyone understand what these laws are so you don't inadvertently run afoul of them. Now, I'm going to be talking about the Federal Trade Commission Act, which is from the 1930s. And I want you to keep in mind what the purpose of this is, as stated by the Second Circuit. The law was not made for the protection of experts, but for the public. That vast multitude, which includes the ignorant, the unthinking, and the credulous. When we are talking about this act, we're not talking about the informed consumer. We are talking about the ignorant, the unthinking, and the incredulous.
Talking about most people.
Yeah, and that is the standard we are using. H.L. Mencken had a quote kind of like this: "No one's ever gone broke by underestimating the intelligence of the American public." It's the same principle here. There are two particular provisions in the FTC Act that we care about, Section 5 and Section 12. Section 5 says that you can't use unfair methods of competition or unfair and deceptive acts or practices in or affecting commerce. In other words, if you're selling a product or a service, you can't make deceptive claims about it. There is then Section 12, which governs false advertising. And this is related to Section 5, and in fact a violation of Section 12 automatically is a violation of Section 5, but it prohibits false advertisements for food, drugs, devices, services, or cosmetics. The term false advertising is defined in another statute. It is an advertisement other than labeling which is misleading in a material respect. And there are two important caveats I'm going to put on this. Number one is it's not only the express claims that you make, but it's the implied ones as well. If you show a commercial of people taking a pill and they start out really depressed and then they look really happy, but you don't expressly say it treats depression, well, what's the implied statement by that visual progression that you saw on the TV screen, right? This is why in commercials you see things like, for example, two people who, or you see a guy who's having trouble getting an erection who drags two cast iron tubs to the top of a hill, and and apparently that's romantic. I mean. If he could get him up the hill, I'm not sure what his problem was cardiovascularly, but whatever. So that's the first point. The second point is, not only is it what you include, it's what you don't include. You have to include, you can't omit material information. This is why when you watch a drug commercial, you have about 5 seconds of what the drug does and 25 seconds of all the nasty things it's going to do to you if you take it, right? It's because... Right. Yeah, exactly. And then it asks, ask your doctor if this is right for you. Now, they are clever because even though the audio is pretty bad on it, they have this great visual of people being happy and dancing and, holding up grandchildren and that sort of thing. But, but that's the point though. They have to include that stuff if it's potentially material. Say, that's a good observation, actually. The observation being maybe in these drug commercials, they don't necessarily show the person as being ecstatic. They show them sort of on the way to recovery. And the reason may be because of this. They feel better. They can sleep, I mean, Lunesta, thank God we know that that one of the side effects of a sleep pill is that you might be drowsy. I mean, drowsiness is a side effect of a sleep medication. Who'd have thunk? So let's break all this down, right? What are the legal requirements for a deceptive representation? Well, first of all, we need a representation, right? If we don't make a representation, we don't have a problem. And remember, the representation is not only what's explicit, it's also what's implied. Second, the representation was likely to mislead consumers acting reasonably under the circumstances. And then last, the representation was material. Now, just a couple things for our purposes. If you make a representation about health benefits, it is usually considered material. It's presumed to be material. Similarly, if you make a representation in selling a product or service, again, it's presumed that the representation is material, because if you're making it in the context of trying to sell a product, well, yeah, it just appears on its face to be material. Now, the first and the third requirements usually are the easier of the two. The second one's a little bit more complicated. You can establish that something is likely to mislead consumers in two different ways. One is that the statement itself is actually false. You say X and the truth is really Y. The other way is if you don't have adequate substantiation for the truth of the message, right? If I say a product will cure cancer and I don't have any studies that suggest this product would actually cure cancer, that's a deceptive claim because we don't have anything to support it. Now, I'm going to throw a bit at you, but I promise we're going to do some examples later on that will illustrate it. But what exactly is a reasonable basis, right? Well, we get a little bit of help from case law. We don't get a lot from the statute itself, but in the case of health-related claims, this reasonable basis must, at minimum, consist of competent and reliable scientific evidence. Well, what is competent and reliable scientific evidence? The FTC has helped us define that. Tests, analyses, research studies, or other evidence based on the expertise of professionals in the relevant area that have been conducted and evaluated in an objective manner by persons qualified to do so, using procedures generally accepted in the profession to yield accurate and reliable results. Sounds a lot like peer review. You know, scientific studies, double-blind studies, that sort of thing. Why am I telling you about this? Well, one of them is to give a shout out to our science committee. If we're going to make health claims about resistance training, we need to be aware of studies that show it. And through the last 3 or 4 years, I forget how, yeah, 3 or 4 years, the science committee has done a painstaking review of all these different papers to help us say this. So they are really helping us in this respect. They are helping us get a reasonable basis for this. But the other thing is that if you're going to make a health claim, you got to make sure there's something to support it. Health claims are what the FTC clamps on very heavily because health claims are presumed to be material. So let's do a couple examples just to talk about it. Starting strength will give you better long-term health outcomes, or will give you better long-term health outcomes than any competing program. All right, so what's the claim? Claim is, again, fairly straightforward. Starting strength will give you a better health outcome than any other program you do. Is this a problem? Yeah. I think it is, because you're making a health outcome statement. And as soon as you start talking about health, you need to have some kind of a peer-reviewed study or a scientifically valid study to show that. And we don't, at least to my knowledge, we don't have that yet. Also, since it is misleading, we also have to ask, is it material? Well, sure it is, right? In this context, it's pretty obvious we'd be saying it in the context of pushing the starting strength program, and it makes a health claim. So in my view, that's two presumptions that it's material, and I think that's exactly what somebody would say.
Is it proper to define material?
Proper to define material?
What do we mean when we say material?
I'll go to Potter Stewart on this one. I know it when I see it. It's basically something that the consumer would likely examine when they decide to buy a product. So, would a reasonable consumer buy a product on the basis of this representation? And when we look at, for example, starting strength, why do people want to do starting strength? Because, what we say is it will get you results. We know this from our own experience. Well, when we say that, we're basically pitching the program to them. So, and that's why they would do it. I think that's why most people in here did it, because we thought, well, it seems to get results, so that's why we'll give it a try rather than something else. Claim 3, starting strength is the best fitness program on the market. What's the claim? We're number 1. Is this deceptive?
No,
No. Why is it not deceptive?
because it's basically a statement of opinion rather than
Yeah.
a claim of fact.
Right. It doesn't mean anything,
Completely editorial.
right? It is what courts call commercial puffery, where a claim is merely exaggerated advertising, blustering, and boasting upon which no reasonable buyer would rely. It may be unactionable puffery. Everybody says they're the best, right? Starting Strength is the best fitness program on the market. What the hell does that mean? You know, it looks like an example of commercial puffery. A consumer is not going to say, oh, well, you know, they said it, so they must be the best. You know? Yeah, Lake Wobegon, where every kid is above average, same deal here. Everybody's the best. Every auto mechanic is the best one. In fact, some of them even have that in their name. Claim 4. If you follow Starting Strength, you can expect your squat to double in 2 months. This is a pretty specific claim, right? Is it deceptive?
No,
Why do you say no?
because you can expect all kinds of shit.
Okay. But remember, Dr. Dr. Sullivan, for all the crap you give lawyers, that was a very lawyerly parse right there. See, I think this one could be problematic. And the reason why is you are making a very specific claim. You are saying within 2 months, you, the person we are targeting this program to, can expect to double your squat. Now, a lot of people may have that result, but do we actually have some kind of formal data that shows it? Now, why am I asking that? Now, why am I asking that question? Well, yesterday we had a presentation from Nicholas Raculia talking about how we can actually get data to show the efficacy of the program. Jordan's going to talk about the same thing later today. Guys, this is important. This is important data to collect. And what we saw yesterday is if we go solely on the basis of self-reported data from people who aren't coached, even though it still shows that we have outcomes, it is a kind of a garbage in, garbage out problem, right? You might have somebody who drastically overshoots their first workout. You might have folks who are, who just don't recover properly. It helps to have a coach to help standardize everything, right?
17 out of 402 that did it right.
Yeah. And so, this is why, so the take-home messages for all of this, number one, and I think the most important one here, is that Jordan Feigenbaum's data project, which Nicholas Raculia also discussed, is really important. Because if we get data showing, let's say we got data that showed this, wouldn't that be a pretty powerful statement we could make? That our average or our median trainee or 75% of our trainees or whatever the number actually says doubled their squat in 2 months? Wouldn't that be a really great statement we could make? But the problem is we don't have the data for it yet. So if we were to make this statement today, we might have problems with it. But if we get that data and we get something published in a peer-reviewed journal, sky's the limit.